raised. Mr. Mutuku urged that by not raising quorum non-judice at that juncture, it is deemed that the matter proceeded by consent of all parties, and the fifth accused effectively acquires his right to raise that issue. Now, regarding the case, Mr. Mutuku urged that at the time of the elevation to the Court of Appeal bench, this court had 42 prosecution witnesses, with 2 prosecution witnesses remaining to close of the case. It was his submission that this court's ascension to the Court of Appeal did not rob the court of the unlimited original jurisdiction to conclude the matter. Mr. Mutuku urged that this was not a new occurrence in Kenya's history in the administration of criminal justice. He drew court's attention to the 6th announcement of the Judges and Magistrates Vetting Board, dated 15th of January 2013, by Sharad Rao, who was chairperson of the board, touching on the determination number 5 of the board. It is a post-2010 occurrence. Council gave example of 2 judges appointed to higher benches from the High Court in 2011 and 2012, who sought for and obtained leave from the Chief Justice to be off the course list of the higher courts in order to finalize their pending matters in the High Court. I have considered the submissions of learned counsel Mr. Michuki and also Mr. Mutuku on the issue of quorum non-judice. The arguments of Mr. Michuki are that after this court heard the entire case, it ceased to have jurisdiction to write judgment on grounds it had since taken oath to serve in a higher bench. He quoted no legal provision to support that position. At the same time, he acknowledged that there was no law that spelled out which court had jurisdiction to hear murder cases, stating that indeed the jurisdiction of the High Court to hear such cases was out of practice and custom in exercise of its original jurisdiction. If I heard Mr. Michuki well, he was at a loss whether the law supports the trial of murder cases by the High Court. In other words, I did not have jurisdiction to hear the case in the first place. He is not alone in that dilemma. The issue of the jurisdiction of the High Court to hold murder trials was the subject of a case, that is Charles Henry Nyaoke versus Cabinet Secretary for Ministry of Interior and Coordination of National Government and 4 others. It was a High Court petition, Kisumu, in which I was the presiding judge. Now, in that case, the court observed, and I quote, "As regards criminal cases, the criminal procedure sets out further jurisdiction of the High Court in the exercise of its original jurisdiction in criminal cases under Part 2 titled Powers of Courts. It provides, subject to this court, an offense under the Penal Code may be tried by the High Court or a subordinate court, by which offense is shown in the 5th column of the first schedule to this court to be triable. An offense under any law other than the Penal Code shall, where the court is not mentioned in that law, be tried by that court. Now, where no court is mentioned, it may, subject to this court, be tried by the High Court or by a subordinate court, by which the offense is shown in the 5th column of the first schedule to this court to be triable. Now, under the 5th column, the first schedule of the Criminal Procedure Code, the court which may try a person charged with murder under Section 203 of the Penal Code is not indicated. We have carefully evaluated the rival submissions made by the parties to this petition. In that regard, it was clear to us that the parties herein are asking the court to interpret Article 165(3)(c) of the Constitution to determine the delineation of the jurisdiction of the High Court in hearing and determining criminal matters in exercise of its original jurisdiction. In the present petition, it is apparent to this court that the assignment of jurisdiction to the High Court to hear murder and treason charges under the Penal Code under Section 4 and 5(2) of the Criminal Procedure Code may appear to be arbitrary if the history and the context is not taken into consideration for the proper understanding